Good morning, everyone, and thank you for joining us this morning for our webinar on the outlook and impact of proposed revisions to China's arbitration law. My name is Thomas Allen, and I'm the global lead for international disputes at Kilpatrick Townsend. We had promised a 30-minute webinar, and there's a lot to cover, so let's jump right in. I think we're all aware of China's importance to the global economy, and I think we're also aware of the importance to businesses of having a stable legal system in China, a stable and predictable legal system in China for dispute resolution. As you can see from some of the eye-popping statistics here on the slide, arbitration has been a preferred method for resolving disputes in China for some time. Of these figures, keep in mind that the overwhelming majority of the millions of cases that are listed are likely domestic cases. However, parties from over 100 countries and regions have in fact arbitrated in China. Now, the drivers for arbitration, I think, are probably also well known to this group. First of all, Chinese courts have had a reputation in the past for favoring local parties. We hear many criticisms of the uneven quality of the judicial process in China. That quality may vary widely depending on the region that you are in. And if you are litigating in Chinese courts, your choice of counsel is going to be limited. Now, enforcement is one. You see the last three bullets there all apply to enforcement in one way or the other. And when we're talking about enforcement here as an arbitration driver, we're talking about enforceability across borders. Enforceability across borders is one of the principal drivers of international arbitration. There are 160 countries that are members of the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. And as the name suggests, that treaty, that convention, calls for reciprocal enforcement such that you can enforce an arbitration award in any of those member countries. That's different than court. So the reason why arbitration is often selected is because PRC courts generally will not enforce court judgments absent a reciprocal treaty. And while there are roughly 30 such treaties that deal with the reciprocal enforcement of court judgments, there is no such treaty between the U.S. and China and many of China's major trading partners. And not only would it be difficult for you to get a foreign judgment enforced in China, it would also be difficult for you to take a judgment from a PRC court and then enforce that judgment abroad. So arbitration in China has improved a lot over the years, but it's still imperfect. China has made considerable efforts to improve. That top bullet there on the mandatory reporting system is something that you have perhaps heard about in the past. I mentioned that there is criticism of the judiciary in China as being not uniform. Not all of these criticisms, by the way, I'm repeating criticisms, but not all of them do I necessarily share, but I do think they are pervasive in the marketplace, so they are worth discussing. What the mandatory upward reporting system says is that if in fact you have a lower court or an intermediate court fail to enforce an arbitration agreement or an arbitration award, that decision automatically has to be reported up to the next higher court. The idea there is to set up a system where those higher courts can ensure that the lower courts are enforcing the law and enforcing China's policy that favors arbitration. Now, China's policy favoring arbitration has been developing since 1994 when it first adopted its national arbitration law. Since that time, we have seen the growth of an active population of international lawyers who are making their home in China. We also see lots of indication of support from the Supreme People's Court of China for arbitration, including a number of advisory opinions to try to address some sloppy precedent in the past, as well as some public remarks by some Supreme People's Court justices that have been very effusive in terms of their treatment of arbitration. Having said that, lots of doubts are out there. I think many of you that are in-house and that are, that are here today are in part here because of the fact that you may still have some suspicions about the status of arbitration in China. What are the suspicions as to whether China can truly be neutral? One of the major ones I hear are concerns over impartiality of arbitrators. There's also concerns that you often hear voiced about arbitral institutions and whether or not they are too political and whether or not they favor local parties or connected parties in their decision-making process. A lot of this is anecdotal evidence, but we have a lot of anecdotal evidence of delay, inaction, allegations of corruption or evident bias on the part of arbitrators, and a host of other issues. China, the government of China, is aware of these criticisms because it is, in a way, taking them head on in this new law. And the Ministry of Justice in China issued some explanatory notes. And among those explanatory notes, they mention the fact that the purpose of the proposed law, the proposed new arbitration law, is to enhance international economic cooperation, reflect the lessons from international standards, and what we will see is a lot of the new law is codifying practice that has already been well established. Another goal is to promote the protection of legitimate party rights and, in a way, to preserve China's reputation as an arbitral forum in order to keep China competitive as a choice for dispute resolution. Now let's jump into the changes. These are the proposed changes to the arbitration law. A quick footnote on how we were able to analyze this. We made a translation of the law into the English language, analyzed the original text as translated, and also reviewed most of the available scholarship out there. The proposed law is only a month old, so there's not a lot yet that's been written about it. So this webinar tonight is kind of breaking news in that regard. So what's different? First, previously there was a requirement under the arbitration law in China that arbitration had to be between equals. And this was seen as precluding investor-state arbitration and sports arbitration. That has now been clarified. Ad hoc arbitration, which, as we know, is arbitration that occurs without the benefit of an arbitral institution, used to be prohibited under the old arbitration law in China, and under the proposed law, it will no longer be prohibited. But that will only apply to disputes that are foreign related. It will still be prohibited, ad hoc arbitration will still be prohibited with respect to domestic arbitrations. Now, the permissive, the allowing of ad hoc arbitration to move forward is significant because under the old regime, the failure to designate an arbitral institution could be grounds to invalidate an arbitration agreement. And we actually I've given a lecture on this subject in the past before PLI, where I went through some of the precedents on this in Chinese courts, and you can see that there were a couple of cases, in fact, where the failure to designate an institution with an otherwise valid arbitration agreement, that agreement was thrown out. Now, I think now that that's no longer the case, you want to pay attention if you are drafting your dispute resolution clauses to Article 35, because it does provide a number of mechanisms that are designed to aid in the formation of an arbitration panel and to aid in the selection of an arbitration institution if the parties can't agree. And there's even a provision in there that I interpret as a race to the arbitral institute type provision. So look at that carefully, because there is some first filed aspect to it when there is ambiguity as to what institution applies. But it's no longer fatal to your agreement to arbitrate. Another hugely significant feature is the fact that foreign arbitration institutions will officially be able to register and operate in China as legal entities. Some of them are already operating in China unofficially. The fact that they can now officially open, register, and operate should really change the competitive landscape in China for the availability, both in the quality and quantity of arbitration institutions that are available to you. So that's significant in terms of the choices that you have in arbitrating in China. Additionally, now competence is the phrase that we often hear in arbitration. That's reflected in the next bullet there of Article 28, which essentially now codifies the fact that arbitrators are permitted to determine their own jurisdiction. So they can handle questions of arbitrability that is officially in the text. There are opportunities for judicial review of a decision invalidating an arbitration agreement, but they're limited, and objections that are not timely made can in fact be waived. And those objections also shouldn't disrupt the arbitration. The text of the law officially says that in fact the arbitration may proceed notwithstanding those objections. Interim measures. This is a big change. Under the proposed law, arbitrators will be permitted to grant interim measures. We usually see these in the nature of preservation orders. I like to think of this as orders that are necessary to preserve the meaningfulness of the arbitration, or to preserve the subject matter of the arbitration, so that the arbitration won't be, I should say, not preserve the meaninglessness, but so that the arbitration will not be meaningless if, for example, evidence has been destroyed, property has, or assets have been dissipated or hidden. And so this is a tool in the toolbox of the arbitrators now to issue preservation orders that will be done on an interim basis. Usually they take the nature of some kind of injunctive relief or security orders. There are some, in the text of the law, the time frames are emphasized that both courts and arbitrators should act promptly when they receive applications for interim measures. And notably, the Articles 43 through 49, and principally it looks like 48 and 49, provide for judicial assistance domestically to enforce those interim measures. So the court will enforce interim measures in China against PRC counterparties. That's something, having that ability in the midst of an arbitration, if it happens the way it's laid out here, is significant. Extraterritorial jurisdiction is all, extraterritorial judicial enforcement is also expressly permitted in the new law. That, again, is something that is hugely significant, because what that means is if you have an interim measure and the arbitrators have reduced that to an award, you may be able to enforce that measure outside of China as needed. Those of you that follow the jurisprudence in the United States know that there's a question, there's a circuit split actually, about whether or not courts can issue injunctions in aid of arbitration. So I think the express permission here might cause some of the federal courts to rethink that question, at least if they're dealing with an arbitration award that is coming out of China. There's also procedure for emergency arbitrators if, in fact, you need those types of interim measures or preservation orders on an emergency basis. I talked about some of the concerns with arbitration, and principally concerns related to both the power of the arbitral institutions as well as the impartiality of the arbitrators. One thing that is intended to cure any lingering doubts in the new law is a provision that provides that the roster of arbitrators that is designated by an institution is not considered mandatory. It is only recommended, and parties are not bound to choose from the roster. Many people think that the rosters at some of the larger arbitral institutions in China are very political, and they'd like more flexibility. This renders those lists only advisory and not mandatory. Also, institutions are no longer the predominant selection body for appointment of the chair. They are given less control over that process. CTAG exercised a lot of control over the appointment of the chair in the past. Now it's clear that the party appointed arbitrators can appoint the chair. And institutions are given the authority upon good cause to remove an arbitrator. But again, these rules are designed for transparency and improving the confidence in the arbitral system. So if an arbitrator is removed, the Arbitration Institute needs to specify the reasons for removing that arbitrator. More on independence and transparency with respect to arbitrators. We see here that there are new requirements. These are, I would say, in line with international standard and practice at many of the arbitral institutions already, but they're made express now in the proposed law. Arbitrators must certify their independence and make a written disclosure of any apparent conflict. Their independence, their certification of independence must actually take the form of a declaration as to neutrality and fairness. And arbitrators are required to disclose in writing to the parties if they're aware of any circumstances that may cause the parties to have reasonable doubts about their independence and impartiality. That is pretty standard type language on an international basis, but the fact that it is now law in the People's Republic of China, I think, is significant. One question that I have in my mind that I don't know is if you can prove that an arbitrator has violated this portion of the law, is there in fact recourse? And would that in fact, if there were recourse against those arbitrators or if they were subject to other liabilities, I think that's something that could be significant in terms of adding some teeth to provisions that are designed to ensure neutrality. Again, a lot of these new provisions are codifying international standards. Parties are given expressly in the proposed law the power to fashion their own procedural rules, and virtual arbitration is expressly permitted. I have a lot of thoughts on whether virtual arbitration is always appropriate or if it's ever appropriate, but that's really a question for another day. At least in the age of COVID, it's nice that there's no ambiguity about whether or not virtual proceedings would be allowed in China. Also, the next bullet, I think, just captures what was said before, that the parties have broad control over determining in their dispute resolution clauses the method of cross-examination. And the default is that the arbitrators are the gatekeeper in terms of weighing the credibility of evidence and assigning the burden of proof. Additional changes. This top bullet here is, again, something that I think is already the default rule in most jurisdictions, that the law designated by the parties as being applicable to the arbitration agreement is the law that should be applied to questions of the validity of the arbitration agreement. But failing that, the law of the seat of arbitration shall be the applicable law for arbitrability questions. And when we say the law of the seat of the arbitration, if we're determining the seat of arbitration in our clause, in our disputes clause, then that law would be the national law, the national arbitration laws of the country involved. There are provisions for mediation, and I talked about enforcement before and how enforcement is really one of the key drivers for arbitration. And so I think that the bullet here in articles, referencing Articles 69 and 70 of the new law, shows that, in fact, you can take a mediated settlement, and there are procedures to initiate an arbitration and to have that mediated settlement reduced to an enforceable award. And we talked about enforceability across state borders in the New York Convention. So having a mediated settlement become an enforceable award is something that's significant. The next bullet, I think, reflects the fact that the methods of service in arbitration do tend to be flexible. We've talked about the fact that this is a pro-arbitration law. And so because it's a pro-arbitration law, there are certain procedural preconditions that if they are not met and a party is aware of them, they will be waived. We already talked about the provision for enforcing interim awards. We talked about that in the context of preservation orders, but there's also a provision for enforcing awards that are rendered that are partial awards and that are not yet the final arbitration award. Now, Article 75, which is the next bullet, gives me a little bit of heartburn. I don't think it's particularly unique in terms of national arbitration laws, but what this provision does is it allows the courts to seek clarifying questions if there's something unclear about an award. And that's during enforcement proceedings in court. And why I'm concerned, or at least think this bears watching as to how this is implemented, is because I think provisions like this might invite the courts to wander into the merits of the dispute. And that's something that is not consistent with what I think the policies and virtues of arbitration are. But because this is a pro-arbitration law, they have cut the time frame for challenging an award in half. That is significant. They have also unified in the proposed law the grounds between a domestic award and an international award for canceling that award. Previously, there were different grounds for canceling a domestic award than there were for canceling an international award. And here, and when I mean international, I'm saying we're still talking about awards that are rendered or sought to be enforced in China, but they're foreign related. What you're looking at here is our unofficial translation. And you can see what we have in blue is we've stated the new grounds in blue. So that's what the blue represents. And if you see these standards here do track the model law in a lot of ways. But again, if you look at the bottom language here in blue, you see that an application for revocation can be partially granted. So again, I'm not sure how partial invalidation of an award is going to work in practice. So that's something that we want to watch to make sure that the courts aren't intruding to the merits again. So I'd look at that one in terms of Article 77. And this is another provision that I've highlighted. And here again, you see that we have the new sections of the law in blue and we have the old section in black. So under the old section, there could be judicially ordered re-arbitration of certain matters within a specified time limit. I think of that as a remand, as an appellate court remanding to the trial court in a way. And I think that this is another one that is this provision is a bit fraught with peril because I don't know how it's going to work in practice. If an arbitration tribunal determines to send the matter back to re-arbitrate certain issues in order to cure potentially fatal flaws in enforcement, I'm concerned again that is an invitation of the court to take a little bit more license with the merits of the dispute than makes me comfortable. But we'll have to wait and see. And as I said, it's not completely different than the laws in some other countries, including civil jurisdiction. But the law in the United States does not really provide for this type of re-arbitration and remand. So there again, we got to watch that one. So where does this take us? And I had a question here, and the question goes nicely with this slide, which is, in my opinion, do the changes in the new arbitration law make China more acceptable as an arbitration jurisdiction compared to other preferred jurisdictions in Asia? And I think the answer is that I think it makes it more acceptable, but I don't think it makes it more acceptable on a comparative basis to, say, a Singapore, for example. I think that positive steps have been made in terms of helping to implement a stable system in China for arbitration. However, I think we really need to take a bit of a wait-and-see attitude to see whether this system will be followed and whether the courts will follow it, as we are accustomed to under the principles of the rule of law and the features that we look for in a stable national system of laws. This is still a communist country, a socialist country, so we do have to, I think, take a wait-and-see attitude to see if the courts are going to truly enforce this down the line. And so what I say is, and we're getting short on time here, but basically what my approach here is to try and negotiate yourself out of China. If you're negotiating yourself out of China, you should realize that you may not be able to escape the PRC courts completely, because unless you're dealing with a counterparty that has assets outside of China, you're still going to have to go into China to try to reach those assets. And so you will find yourself within this enforcement regime, even if your award was rendered outside of China. So the short answer to the question is, I'm not completely sold, and what I have here is a checklist that is non-exhaustive, and this is something that I tell parties that ask for my advice when it comes to negotiating with PRC counterparties. First, I say do try to negotiate arbitration seated outside of China. I think that the past evidences of problems is fresh enough that you may not want to be an early adopter, and so I'm recommending arbitration seated outside of China administered by a non-Chinese arbitral institution. However, that's not always going to be possible. So in your negotiations, if your counterparty says no, we're insisting on China, I like to propose Hong Kong as a fallback. Hong Kong might be a little bit more palatable to that party on the mainland. The Hong Kong International Arbitration Center does have a strong reputation for enforcement of its awards on the mainland. Hong Kong has, up until now, maintained a separate legal system. As China consolidates power over Hong Kong, we do want to keep an eye on whether or not Hong Kong remains judicially independent. But for now, they have a very well-developed system of arbitration laws that I think has stood the test of time. If your counterparty insists on arbitration in China, if they don't want to go for Hong Kong, you might take advantage of the new law and propose an international arbitration institution, a foreign institution, to administer the matter, but do so in China. So since these institutions can now register in China, you might alleviate a lot of the concerns that are being bandied about the Chinese arbitral institutions if, in fact, you get something like the ICC or the SAIC operating in China. Those institutions are well established. They have great credibility and reputation for neutrality. There's other things you can do as well. I think that if you've heard me lecture on arbitration topics before, you know that I think that the first step in winning a dispute is negotiating in your dispute resolution clause. I think the more chances you can build into your clause, that will help you make sure that your panel is neutral and that your arbitrators have the type of attributes that you think are important to the case, then you should try to negotiate those. And the more control you can assert over the arbitration selection process, then the better chance you're going to have of alleviating some of the concerns about what arbitrators ultimately get. You can do things, for example, like include a limitation on the nationality of the chair of the tribunal. You can modify the rules of appointment. There's lots of different creative things that you can do to protect yourself because arbitration is, in fact, a feature of contract. So with that, that's actually my last slide, and I'm at 32 minutes, so I think I did pretty well in terms of my timing. I do have a question about whether or not I'll share the slides. I'm happy to share the slides. If you could send me an email, I can route them out to you so that you can get the slides. And I am happy to continue this conversation as well with any of you or your organizations individually if you have additional questions. It's a lot to process in 30 minutes, but I hope that this at least gives you an idea of what the landscape of the new law looks like and also gives you some tools in your toolkit for negotiating your disputes clauses with PRC counterparties. Thank you very much.